Oh, good. We have a clock.
Yeah. All right, welcome to the American Enterprise Institute. Thank you all for coming to this event on sensible regulation of e-cigarettes, opportunities for reform. What we're going to do is relatively straightforward. In 90 seconds from now, Sally Sital, my colleague, will give an introduction to the topic of e-cigarettes, some of the evidence of the non-pernicious nature of e-cigarettes, and the broader public policy debate surrounding it. We will then turn to Greg Conley of the American Vaping Association, who will discuss the current regulatory regime and some of the problems with it. After that, my colleague Alan Viard will talk about the goals of the reform in the title of the event, what statutory changes could be made that would be helpful, and also some of the tax decisions that have been made in this sphere. After that, Azim Chowdhury of Keller and Hackman will talk about opportunities for reform through litigation, and finally, Saul Shivman will discuss how the regulators themselves can create space for reform in this important area. And with that, I would like to ask Sally to kick off the discussion.
Okay. I'm just going to give a very brief overview. I'm Sally Sital. I'm here at the American Enterprise Institute. Just a real brief overview of why it's so important that we have sensible regulation, a regulation that enables smokers to have ready access to a variety of products that can be improved upon in an efficient way, because the current regime does not permit that, as the rest of the panel will elaborate and also provide some potential solutions. Just again, broad overview. I think everyone here knows e-cigarettes are an extraordinarily disruptive technology as a way to deliver nicotine without combusting tobacco. Even though they're considered tobacco products by the CDC, there is no tobacco in e-cigarettes. It's a nicotine solution that's heated and does not, because there is no combustion, provide any tar or carbon monoxide. They're not completely safe, and no one ever makes that claim, but they are certainly safer, and hence the term harm reduction is frequently invoked when we talk about electronic cigarettes and vaping. Estimated to be about 95% safer by the Royal College of Physicians. We often hear this estimate. Some people will say 80 to 95%. The point is that based on at least a chemical analysis of e-cigarette vapor and toxins that have been measured, it's between 80 and 95%. Some people even say 99% less emissions. The e-cigarette also, or I should say e-liquid, also contains, in addition to nicotine, propylene glycol or glycerin, which is the vehicle, and that makes the big cloud. These are substances that the FDA considers, quote, generally regarded as safe. They are in cosmetics and theatrical fog. Long-term exposure to vaping is a little bit different, so it's not clear what the effect of 20 years of propylene glycol inhalation would be. After 7 to 10 years of use of these products, there aren't any pulmonary developments, but we don't know, so that needs to be followed post-marketing. But so far, there's no evidence of damage from that. And in any case, again, overall, this is a relative matter. It's safer than smoking, yes. Also, more health benefits in people who do smoke and who have switched, reduced blood pressure and improved lung function in asthmatics. It's also cheaper than smoking. In this country, there are about 8 million vapers, and about 2 million of them have made the complete transition to quitting smoking. So that means 6% are dual users, and to use dually means you use fewer cigarettes. So again, that is still safer. even if you don't transition, although that transition to complete cessation of combustibles, although that certainly is the goal. According to the CDC, vaping is now the most popular device for quitting. 35% of smokers have used that, compared to gum and patch combined, which accounts for 25% of people trying to quit. So that's encouraging. It's even bigger in the UK. The concerns about e-cigarettes are, by now, we've been studying them for a good, or at least the CDC has been following them for a good 6 years, beginning in 2011. Virtually all of them are either overblown or without merit. I'll just list a few of them, and then we'll move on to you, Greg. Nicotine, the danger of nicotine is certainly exaggerated. Nicotine actually, no one's promoting nicotine use in teenagers. I'll stipulate that. But in otherwise healthy individuals, there is negligible to no risk of nicotine use. Certainly one would not advise it for pregnant women, although they have used nicotine patches successfully. And by success, I mean in terms of an absence of fetal or damage in the newborn babies. And certainly if one has a fragile cardiac condition, it's not a good idea to vape, but it's not a good idea to use any stimulant, and doctors will tell folks not to even drink caffeine. So nicotine, any concerns about nicotine is generally overblown. There's an excellent publication on this from the Truth Initiative that goes into this in much more detail. Will e-cigarettes normalize smoking? Clearly that's not happening. Smoking among adults is the lowest it's ever been, now a little bit under 16%. Is it a gateway in children? No. As we've seen, vaping among kids, actually until this year, had been going up. For some reason, between 2015 and 16, it's gone down, which is an interesting question, I guess we can talk about later. But the point being, while vaping was increasing among teens, smoking again was going down. So the gateway effect was not demonstrated, and some have argued that perhaps the e-cigarettes, in fact, allowed some smoking teens to exit the ramp and to get off smoking. And finally, flavors, they're attracting children. This is frequently the concern that's, I think, motivated a lot of the vaping bans in various states, and also taxation issues. Are they attracting kids? Well, they seem to stop attracting them last year because, as I said, there were fewer kids smoking. But in any case, the bottom line is teens who vape, actually very few of them, maybe 20%, actually use e-cigarettes that have nicotine. Very few of them use daily, and those who do are kids who are already using combustibles, so that's clearly a relative improvement for them. Do they like flavors? Yeah, but they equally talk about in surveys how important using a lower risk product is, and those who do vape, as I said, regularly are using it to quit. So the national debate has been incredibly muddled on this, a lot of half-truths and distortions and alarmism that are coming from agencies and nonprofits that one would want to trust, like the CDC, the American Lung Association, many state departments of health. So frankly, a lot of irresponsible scaremongering, and it's gotten into the media, which is really troubling because it's clearly discouraging some smokers from trying these. So that's why the regulations have to be sensible so that they allow the industry to flourish and make these products available, and not go bankrupt, and be able to innovate nimbly so more smokers will switch. On to you, Greg.
Thank you, Sally. My name is Gregory Conley. I run a nonprofit health-based advocacy group called the American Vaping Association. And I have been active in this world for coming up on 7 years in August. It was when I had, in August 2010, quit smoking with the help of a watermelon-flavored vapor product, and saw the hatred and the prohibitionist mindset that was being applied to these products, with many states like New York, Maryland, Tennessee back in 2010 considering bills to just ban the sale of e-cigarettes while leaving cigarettes freely available. And I'm kind of here today to talk about how we got to where we are with the regulatory system and actually what that means. And so what is causing all of the issues for vapor products at the federal level is the act known as the Tobacco Control Act. And that was passed in 2009 after about 10 years of lobbying and negotiating and fighting for that bill. And how that bill came about is not the usual way that a supposedly anti-tobacco bill gets passed. The usual narrative when you have an anti-tobacco bill is it is the health groups, the white coats, against the tobacco industry. That's not how the Tobacco Control Act actually came to be. It came to be because Philip Morris, the makers of Marlboro, the largest cigarette company back in the 90s and still today, they slowly came to the realization in the 1990s, after settling massive lawsuits with state attorney generals, after being sued continually for so many different products and so many different ills, that the old way of working, the just keep fighting in the courts, keep lobbying, just stand firm, that wasn't going to work forever. And so they theorized, how do we get federal regulation of tobacco that not only protects our products, but allows us to stay in business for years to come and retain dominance? That's kind of where the idea for the Tobacco Control Act came from. It evolved through nearly a decade in Congress, but when it passed in 2009, it came with it with a provision that came to be known. Senator John Enzi called it the Marlboro Protection Act for a reason. And the reason why was that it set up a system where the date that the bill was introduced in the Congress prior to the one it passed, February 15th, 2007. It set up February 15th, 2007 as the quote-unquote predicate date. And that meant if your product was on the market on February 15th, 2007, then minus some other points that you could get into, the product was forever safeguarded. Marlboro cigarettes could not be banned by the FDA. Camel cigarettes could not be banned by the FDA, minus product standards that would need to be litigated in court. And so, unfortunately, at the time the Tobacco Control Act passed in June 2009, there was barely any knowledge of the fact that innovation in the tobacco and nicotine market was going to be coming. There was very little knowledge that e-cigarettes even existed. And so at the time, when legislators were passing it, they thought cigarettes, roll your own tobacco, pipe tobacco, smokeless tobacco, that's what we're dealing with, that's what the FDA is going to do. And you know what? It's an old product category. They don't really need new cigarettes. You don't really need new pipe tobacco. What you have is enough, so deal with it. Well, how things have changed. Now we are here in 2017 with thousands of just devices alone for e-cigarettes. Then you're getting into the millions when you're talking about all the various e-liquid concentrations that are available on the market. And they are now using, a couple of years ago, when things started to get very heated before the FDA regulation came out, there were lots of calls, including within the industry, for FDA regulation of vapor products. People thinking this is a Wild West. We absolutely need something to protect us from this onslaught of negative coverage of this being an unregulated market. And I was warning people at the time, be careful. You might get more than you ask for. And this idea of a predicate date and pushing products back to February 15th, 2007, it just seemed archaic. It seemed like something that would get people fearful, but it's not something that the government would actually do. This is too big. We'd often hear too big for an industry that back then was all of $1.5 billion. And lo and behold, when the Obama administration's FDA put out their regulation, they had kept the February 15th, 2007 predicate date. So what does that mean for vapor products? What it means was spelled out pretty clearly in the FDA's economic impact analysis of their regulation. The FDA's analysis was very wrong in terms of the number of products on the market, but the end message was correct. They estimated that 98.5% of products on the market would not even apply to stay on the market. They would, quote, exit the market, the nice way of saying you're out of business. And the reason that's going to happen without changes that the other panelists will discuss is that formerly it was August 8th, 2018. Now it is November 8th, 2018 due to a litigation delay. If you have not filed a retroactive pre-market tobacco application for any vapor product that has come to market since 2007, which is every single product on the market today, your product is banned. If you file an application before November 8th and the FDA doesn't like what you've included, you're banned. If you file an application November 8th and the FDA hasn't ruled on that application by November 8th, 2019, you're banned. So you could spend millions and millions of dollars to try to comply with very vague requirements that have been put out by the FDA. And the FDA could still simply never review your application or just turn it down for an arbitrary reason. So this industry has been saying for years, there should be some level of regulation. And so now we're at a time when you have the UK, public health doctors and stop smoking clinics recommending these products to smokers looking to quit. You have Canada taking vapor products from being quasi-illegal to making them into a legal and well-regulated market. You have Australia, which has been the birth of e-cig prohibition or continuing the legacy of e-cig prohibition. Australia, you have liberal Democrats standing up and saying, this is a social justice issue. The poor are our smokers. We need to do something to allow them access to these products. In the United States, meanwhile, we have set up a system where smokers like myself 7 years ago will be extremely limited in our choices, if not completely foreclosed from using the products that have been shown to actually work to help smokers quit. Those are the open vapor products that you refill with e-liquid that give consumers choice. But all hope is not lost. We have an administration that is anti-regulatory state. We have a FDA commissioner who certainly more so than the prior one, certainly more so than the FDA Center for Tobacco Products is Mitch Zeller. Scott Gottlieb used to have an investment in a vapor product company. He even said before the Senate, he talked about the value that flavors may have in helping adult smokers quit. He frames many of his statements about the need to not create new smokers, rather than just abstractly talking about the evils of nicotine regardless of its source. So there is reason for optimism, but time is running out. It is now 14, 15, 16 months from the new prohibition date, and companies are getting worried. There are leases that are coming up. There are contracts that need to be signed. Employees need to know whether they're going to have a job in 2019. So we need change now. It's evident to, I think, everyone in this room, and hopefully the oncoming appropriations bill or the excellent letter sent by some of the public health people, including a couple in this room, to Scott Gottlieb advocating an alternative system that Saul will get into. There's hope. So I am very hopeful today that when we hopefully have another meeting like this in a year, there will be much better news to report. Thank you.
Thanks. I'm Alan Viard of the American Enterprise Institute. I just want to discuss briefly the legislative proposals that have been put forward to try to fix the situation and the problems that Greg has described, and then say a few words about taxes that states are applying to e-cigarettes. The Tobacco Control Act really is the source of the problem for e-cigarettes in the sense that it's a regulatory regime that was designed for combustible cigarettes and may work reasonably well in that context, but which is not remotely suitable for e-cigarettes and other harm reduction products. So if the statute is the underlying problem, an obvious approach would be to try to enact new legislation to replace or modify it. There's certainly a number of advantages to legislation because of the complete flexibility that Congress would have. It could choose the good and reject the bad, keep the aspects of the Tobacco Control Act that do make sense for e-cigarettes, but discard the ones that do not, particularly the pre-market review that Greg was talking about, where millions of dollars have to be spent to submit an application for the product to even stay on the market. The FDA, I think, has considerably restricted flexibility as long as it's operating under the Tobacco Control Act, and the other two speakers will be addressing this. But to my mind, at least, reading the statute, I think it's very difficult for the FDA to change the predicate date or to eliminate pre-market review unless they decide to simply not extend the Tobacco Control Act to the e-cigarettes at all. And in that case, you have no regulation of them at the federal level. So it's almost an all or nothing choice, or at least so many people have argued. Others may see more flexibility there, but certainly Congress has the ultimate flexibility if they pass a new statute. Furthermore, of course, statutes are harder to undo once they're adopted. But the drawback is they're harder to actually get passed in the first place. And so far, we've not seen any statutory changes adopted. There were efforts to put it into the continuing resolution last September, efforts to put it into the omnibus appropriation in May. None of those efforts succeeded. Another appropriation or bill or continuing resolution will be coming up this fall. We'll see what happens. The leading statutory proposal is the Cole-Bishop bill, H.R. 1136, sponsored by Tom Cole, Oklahoma Republican, and Sanford Bishop, Georgia Democrat. It actually has 77 total sponsors, 68 Republicans and 9 Democrats in the House. The key provision is that although it would keep the pre-market review, it would dramatically change its scope by changing that predicate date that Greg mentioned from February 15, 2007 to August 8, 2016. So the vapor products that were on the market as of last August would get the same grandfathered status as the combustible cigarettes that were on the market in February 15, 2007. It would otherwise maintain the FDA's regulatory authority, require the FDA to adopt a product standard for batteries, prohibit advertising designed to reach children, and require retailer registration. A more sweeping proposal is the bill by Duncan Hunter, California Republican, H.R. 2194. Has 3 sponsors, all Republicans altogether, and it would really restructure things in a way that would seem to make a lot of sense. It would change the Center for Tobacco Products at the FDA to the Center for Tobacco Products and Tobacco Harm Reduction. So it would actually put harm reduction squarely in the FDA's mission, require a report within 18 months on the comparative safety of combustible cigarettes, e-cigarettes, and other products. The tobacco product regulatory regime would not apply to vapor products at all. Instead, they would be put under their own separate regime, which would include a ban on selling and advertising to minors. It would include manufacturing standards, but it would not include pre-market review of any kind. I think that really is the more sensible approach and the more far-reaching one. But of course, either of these bills would be a dramatic improvement over the current regulations. Let me just say briefly a few words about tobacco taxes and their potential application to e-cigarettes. Tobacco taxes originally were enacted centuries ago as luxury taxes on the premise that only the wealthy use tobacco. Today, of course, that's not remotely true, and instead they have a completely different rationale, which is to try to discourage the use of a product that has harms to society. That rationale, which does apply to combustible cigarettes, of course, does not apply to e-cigarettes. And so Sally and Alex Brill and I argued in tax notes in April 2014 that the tobacco taxes should not apply to e-cigarettes. And that is the case at the federal level. The federal tax does not apply, and it's still the case in the majority of states. But as the years go by, more and more states have seen fit to take their tobacco taxes and extend them to e-cigarettes. I think that part of this is motivated by revenue concerns. Smoking rates have gone down, thankfully, and that, of course, has driven down tobacco tax revenue for the states. And so they want to make up that money. The logic seems to be, because people aren't buying the product that kills them, we aren't raising as much revenue from taxing that product, so let's tax the product that doesn't kill people. Minnesota actually started this by just concluding administratively that e-cigarettes were subject to the existing tax on other tobacco products that the state had, which was 95% of the wholesale price. Since then, other states have extended their taxes legislatively. California, the District of Columbia, Kansas, Louisiana, North Carolina, Pennsylvania, and West Virginia. None of the taxes are as high as Minnesota, but some of them are quite high. Pennsylvania is 40% of wholesale price, DC 67%, and so on. Local taxes have been adopted in Chicago, in Cook County, which includes Chicago, in Montgomery County, Maryland, and several municipalities in Alaska. Dozens of other states have considered or are considering these taxes. Efforts to adopt them have failed recently in Nevada and Oregon, but I think we have to be prepared for the possibility that taxes will continue to be considered, particularly as states try to look for new revenue sources. So I think it's important to stand firm and say that the logic of taxing combustible cigarettes does not apply to e-cigarettes, and so they should not be taxed on that same basis.
Thank you. My name is Azim Chaudhry. I'm a partner at Keller and Heckman. We're a law firm here in DC, and we represent a number of e-vapor companies in the litigation that's currently pending, which I'm going to talk about in a moment, as well as on the regulatory compliance of FDA. So I have a few slides to help those of you taking notes, but the purpose of my talk is to focus on how litigation might be a tool for helping to reform the regulation and create sensible and responsible regulations. Before I get into the current lawsuits that are pending right now challenging the deeming rule, I thought it made sense to talk a bit about how we got here from a litigation perspective. It actually all started back in the mid-90s when FDA attempted to regulate tobacco products, specifically cigarettes and smokeless tobacco, as drugs. They finalized a rule which treated those products as drugs primarily because they contain nicotine, which they argued was a chemical that has an impact on the body and is addictive. Obviously, the tobacco industry was not afraid to take the challenge and sue FDA. That case went up to the Supreme Court in a decision that culminated in 2000, Brown and Williamson v. FDA, which held that under the law at the time, under the way that the Food, Drug, and Cosmetic Act was drafted, Congress could not have intended for FDA to have authority over tobacco products, despite the fact that they contain nicotine or that they deliver nicotine into the body. The reason for that was Congress would have, treating tobacco products like drugs, would have required them to meet the safety and effectiveness standard that applies to drugs. And since tobacco is an inherently harmful product, at least the tobacco products at the time, there was no way that a tobacco product, a smokeless tobacco or a cigarette, would have been able to meet that standard and would have ultimately been banned by FDA if they were regulated as drugs. That decision led to the Tobacco Control Act. It led to what Greg was speaking about a moment ago, about the need for creating to amend the Food, Drug, and Cosmetic Act to give FDA authority over products, which is what the Tobacco Control Act did. It amended the existing law, the FDCA, to give FDA authority over the manufacture, distribution, and marketing of tobacco products. So around the time that the TCA was being finalized was the same time that these new e-cigarettes were starting to become very popular. Their popularity was increasing in the US. And FDA's initial position on e-cigarettes was the same as it was back in the 90s with cigarettes, that if they're delivering nicotine into the body, they must be a drug or a drug delivery device. And based on that concept, in 2008, they started seizing shipments of e-cigarettes that were coming into the country from China because they were unapproved drug delivery devices. Those companies sued FDA in a decision that went up to the DC Circuit. And the position that they took was that FDA, you may have authority over these products, but not as drugs, but as tobacco products under your new law, which had just passed. The DC Circuit ultimately agreed with that position and held that recreational or customarily marketed e-cigarettes that contain nicotine derived from tobacco meet that definition of a tobacco product, which is anything made or derived from tobacco. And so we're not drugs under FDA's authority. So they've had FDA's tobacco authority, but not their drug authority. Now, this created a bit of a situation because although e-cigarettes or any products that contain nicotine derived from tobacco met FDA's, or excuse me, the statute's broad definition of a tobacco product, the TCA only gave FDA the immediate authority to regulate certain categories of tobacco products: cigarettes, cigarette tobacco, smokeless tobacco, and roll-your-own tobacco. So it defined tobacco products very broadly, anything made or derived from tobacco, but then it only gave FDA authority really over cigarettes, smokeless tobacco, and roll-your-own. And it said anything else, that any other products that meet that definition of tobacco, FDA can regulate, but it has to go through its rulemaking process. It has to deem those other products to be regulated tobacco products. And so we had this gap. We had the 2010 decision from Cetera, that's the name of one of the plaintiffs, that said that these products were tobacco products, but then they weren't subject to FDA's authority until FDA deemed them to be regulated. And so FDA eventually started the notice and comment rulemaking process to create that new rule. In 2014, they proposed a rule. Over 135,000 comments were submitted to FDA during the comment period. And many comments that were submitted argued that FDA should not take a one-size-fits-all approach, which I'll get into, but that FDA should take a reasonable approach to these products. It's use the enforcement discretion that they have as an agency and as provided by the Tobacco Control Act itself, to create responsible regulations, to change the grandfather date, to streamline the PMTA process, to make it more possible for companies to comply and meet what's known as a public health standard. So all sorts of comments were submitted during this process. Unfortunately, the final rule that was ultimately published in May of last year and became effective in August did not really take into consideration most of the comments from the industry, and basically finalized a proposed rule, which, again, all it did was it deemed all products that contain nicotine derived from tobacco to be subject to FDA's Tobacco Control Act authority. So since the rule was published last year, there have been a number of lawsuits filed across the country challenging various aspects of the rule. The Nicopure and Right to Be Smoke-Free lawsuit is the one that is the farthest along. Again, we represent the Right to Be Smoke-Free and the trade associations in that lawsuit. That is currently pending in district court here in DC. There are a number of other lawsuits, mostly filed by vapor companies in California, West Virginia, Alabama, as well as the cigar industry, that also challenge the deeming rule for some of the very similar grounds. So the basis for the lawsuits hinge around some primary areas: the Constitution, First Amendment related to claims, modified risk claims, and free sample bans. The Administrative Procedure Act. So the Administrative Procedure Act is a law that requires agencies to, it holds them to a standard that any agency decision can be argued as incomplete or unlawful if it is arbitrary, capricious, an abuse of discretion, or otherwise not in compliance with the law. And so that's a lot of the heart of these lawsuits. And then there's also the Regulatory Flexibility Act, which requires federal agencies to focus on the impact of regulations on small businesses. And so some of the provisions that are challenged, some of the big picture ones, are the grandfather date, the PMTA process itself, namely the compliance policy, the 2 years until the applications are due, the cost and benefits assessment that FDA partook in prior to promulgating the rule under both the RFA and the APA. We also challenge the free sample ban, the definition of a tobacco product itself, that we'll get into. Well, namely just the fact that components and parts of devices which don't contain anything derived from tobacco are still subject to FDA's authority under their interpretation, as well as the modified risk provisions that require any companies that want to make claims of reduced harm regarding their products. They can't do so, even if it's a claim that their product is smoke-free or tar-free. Those types of claims have to go through a very onerous MRTP process, which is even more difficult than the PMTA process. So part of the lawsuits, some of the themes that are sort of running through them, all come back.
Azim, do you mind
Sure.
walking through the acronyms PMTA and MRTP?
Sure. PMTA is pre-market tobacco application. That's what Greg was referring to as the type of pre-market authorization that all new tobacco products that are not grandfathered have to go through to get essentially FDA approval. And the deadline for that is in November 2018. MRTP is modified risk tobacco process or application. What that means is if you wanted to, in addition to getting simple authorization to enter the market, if you wanted to claim that your products are less harmful, which again, it's pretty well established at this point that e-cigarettes and e-liquids are less harmful products, but you can't say that. You have to get FDA MRTP authorization to be able to make that claim. So that's a whole nother issue. We're still worried about just getting through the process, to stay on the market, but that's what it means. So the lawsuits focus on several themes, and the biggest theme running through all of them is the fact that what FDA has done is their interpretation of deeming is to apply a one-size-fits-all approach. All products that meet the definition of a tobacco product are subject to the same regulatory requirements, that they must go through the same pre-market authorization process. They are subject to the same grandfather date, the same reporting requirements, the same ingredients listing requirements, registration, etc. The effect of that one-size-fits-all approach is that in a year and a half from now, the majority of the industry will be effectively banned because most companies will not be able to submit the PMTA. And the problem with that approach is that the TCA itself, if you look at the findings and the purposes of the act that are set forth right in the statute, the TCA itself builds in a number of concepts that any rulemaking would have to comply with. The idea that adults should be allowed access to tobacco products. The idea that less harmful products should be promoted. And that was actually a whole section in the TCA that discusses that. That FDA should take into consideration lower risk profiles of different tobacco products. They should engage in the flexible rulemaking and use appropriate regulatory controls. And so these are things that if FDA wanted to, they could have turned to as a basis for treating e-cigarettes differently than they are treating them now as the same as cigarettes. They actually made a number of these admissions in the deeming rule itself. If you've read the final rule, the preamble contains numerous admissions that e-vapor products have a lower risk profile, that they're less harmful, that smokers would benefit from transitioning to e-cigarettes and less harmful products. They admit that e-vapor products will not qualify for the substantial equivalence. So the other pathway to pre-market approval is called substantial equivalence. So if you're not grandfathered, you have two options, theoretically, of getting FDA approval. You can go through the PMTA, or you can go through substantial equivalence, which requires comparing your new product to a grandfathered product, to a predicate product. The problem is that no vapor products that we are aware of are grandfathered, that were on the market, and therefore could be used as a predicate product for a substantial equivalence application. And so that entire application process is effectively written out of the statute in the deeming rule because it doesn't apply to vapor products. The FDA admits in the rulemaking that the PMTAs themselves, in order to meet what we call the population standard or the public health standard, require effectively long-term studies, epidemiological studies that show, that would be able to show theoretically that a product is appropriate for the protection of the public health, which is a very high standard, even higher than the safety and effectiveness standard for drugs that applies to new tobacco products. And they also admit, as Greg mentioned, that up to 95 to 97% of manufacturers would have to exit the industry because they will not be able to meet the PMTA process within the next 2 years. And again, the majority of those companies, even vape shops that make their own liquid, would be considered manufacturers and then effectively banned. I'm running out of time, so I'm not going to go through the rest of these slides, but the lawsuit, challenges the grandfather date. The fact that FDA, for those reasons, the fact that they did not change the grandfather date as basically being a violation of the Administrative Procedures Act because of the result of that. Under the RFA, the FDA did not properly consider the costs to the small business entities, and the fact that it would ultimately result in them going out of business and impossible to meet the PMTA standard in 2 years. We challenged the ban on free samples as a restriction on free speech. We challenged the modified risk tobacco process application again as a violation of both the APA and free speech, First Amendment, because again, companies cannot make even factual claims that their products do not contain smoke or do not contain tar or do not contain carcinogens, because those would be modified risk claims that require specific authorization. We challenged the definition of a tobacco product as it applies to non-nicotine components and parts. And again, the big picture one is the PMTA. We challenged that FDA did not consider alternatives under the RFA and APA that would have made more sense. For example, changing the grandfather date, waiting to apply the PMTA compliance or policy until the science is ready, which I think we're still some years away from that. They could have streamlined the PMTA process for products that are on the lower end of the spectrum of the continuum of harm. Many things they could have done that we argued they did not consider appropriately under the APA, and so we challenged that. And finally, under due process, we even challenged, well, let's just say hypothetically, FDA's position is correct, that they are required to do what they did under the statute, that they had no leeway to take a different approach. Well, then we challenged the fact that the Tobacco Control Act itself is a violation of due process because it did not give FDA the tools necessary to do what the Tobacco Control Act says it must do, which is, again, promote safer products, allow continued access to tobacco products, less harmful tobacco products to adults. There were ways that the Tobacco Control Act should have allowed FDA to do that, and if in fact they didn't, then that's a violation of due process. So that's pretty much what the lawsuits look like.
Or not.
Hold it down.
Okay. So just for a change of pace, I'm not a lawyer. I do not play one on TV. I can't help you with your divorce. I'm a behavioral scientist who's been doing research on tobacco and nicotine for a few decades. But I want to talk about, I want to start from the assumption that I think everyone on this panel has shared, which is that regulation of e-cigarettes is needed, but to talk about the possibility of alternative frameworks for regulation that might better recognize the special status of e-cigarettes. As you see on there, I work with Pinney Associates, which currently consults to Reynolds American, part of related to Reynolds Tobacco, we consult specifically on harm reduction and smoking cessation products. And it just makes sense that regulation should start from a sense of what the issues are to be resolved. So I've listed here some of the things that have raised concerns about e-cigarettes, and these are legitimate concerns. That in the absence of regulation, there's sometimes poor quality control, which can lead to things like exploding batteries. Now, those instances are very rare, but they basically shouldn't happen. Coils that heat too high, which can increase the production of toxic components. Sometimes kids, for example, get into nicotine vials and are exposed to toxic amounts of nicotine. There's sometimes misleading information, whether it be about the nicotine content or other matters, and probably the most serious is the question of unnecessarily toxic emissions. And I say unnecessarily because the point again, and Sally emphasized this, these products don't have to be absolutely safe. They just need to be safer than cigarettes, and they should be as safe as they can reasonably be while serving their function. And I think there has been widespread concern about marketing to particularly non-smoking minors, because again, if a kid is smoking, it would be irrational to say, well, you can have a less harmful product, but you have to wait till you're 18. So the concern is about bringing in new converts, if you will, to nicotine use. Really shouldn't be about trying to promote lower risk products. Now, the current framework, as you've heard outlined, is very much a product-by-product framework, and it is the way FDA regulates some other aspects, like drugs, which is that each product has to meet a certain regulatory standard. But there are serious problems with that. One is that it ignores the commonalities, and that leads to a lot of duplication and to a lot of wasted effort, both on the part of applicants and on the part of the Center for Tobacco Products. So does it make sense for each company to have to create research, do a filing to talk about the safety of nicotine when they all contain the same compound? I haven't put it on the slide, but one of the issues is that at least right now, the guidance for PMTAs for e-cigarettes are very vague, so that a sponsor who wants to file an application doesn't really know what's expected, either of the kind of data that's submitted or what the data have to show. So there's a lot of vagueness. And there are some things that really don't make sense for any one sponsor to show. So you've heard mention of the population standard. The idea is that even if you reduce harm to individual users, you need to show that overall you haven't at least increased population harm, which means you need to think about, everyone agrees it's a good thing for a smoker to switch to e-cigarettes, but for example, would you want non-smokers to pick up e-cigarettes? They would probably experience an increase in harm. And so that balance has to be struck. But that effect of uptake by non-smokers is not going to be due to any one product by a particular manufacturer. It's a much bigger issue about the entire environment, not only what products are being sold, what's being said about them, social norms, and so on. So having each sponsor try to create an argument for their, this device with that e-liquid not only is duplicative, but it doesn't make sense. You can't, it's not the kind of thing that's controlled by any one product. So what's the alternative? And one alternative I want to talk about is the idea of product standards. So the idea is a standard is a detailed technical requirement or limit for a specific product. And it's universally accompanied by a very specific test for how you decide whether you meet that standard. And I'm going to give you some examples. Importantly, in order to create the test and the standard, it derives from a product or risk or hazard analysis. In other words, you have to say, well, what's the danger? At what level of, say, a chemical does that danger arise? How low can you get it? So it's inherently kind of a rational approach, and it's very enforceable because you can just say, look, you want to market your product, show that you meet this standard, that you don't have this toxin above the specified levels. Product standards are everywhere. When there are standards that say when your hairdryer falls in the bathtub, it should not electrocute you. It's a good thing. The toys have standards about flammability, as do pajamas and bedding. Very commonly, we have childproofing standards, and there's actually a specific test about how long it has to take a 4-year-old to open a product in order for it to be considered child safe. So it's again an example. You look at a hazard, you set a standard, it has a specific test, and then everyone has to meet it. And product standards are not new to FDA either. So for example, interestingly enough, EPA regulates nitrates, which are also present in tobacco, in your tap water, but if you put it in a bottle, that's under FDA. It happens to be the same standard, which is 10 milligrams per liter, but there's also a standard for smoked fish, which FDA regulates, and nitrosamines, which are also present in tobacco, apparently are also present in baby bottle nipples, and so there's a standard for that. Examples are childproofing, flammability. Product standards are so pervasive that we don't notice them. So in this room, the chair you're sitting on had to meet a standard. The carpet in this room and the glue that holds it to the floor had to meet a standard. The light bulbs in the ceiling had to meet a standard. The projector in that TV had to meet a standard. They're everywhere. And I want to make the important point that sometimes the standard is about disclosure. So for example, in the workplace, there are both standards about how much of some potentially toxic compound you can have in the air, but there are also standards about what you have to disclose to workers so that they're aware of a risk. And product standards are very helpful, and their absence can be catastrophic. So for those of you, we've been speaking about the hazards of combustion. The Grenfell Towers in London burned down because they had revoked the standard that says, you know what, it's a bad idea to have a highly flammable compound on the outside of a tall building. So again, standards are pervasive, and they've proven their value in protecting the public health. So what, in a very summary way, what might standards look like for the hazards that I outlined earlier? I mean, there's a standard already for good manufacturing process that includes quality control. There are already standards about batteries. Samsung notwithstanding, most of the lithium batteries that we carry, for example, on our hips and cell phones don't explode, don't break into fire. You can limit the amount coil heats. You can dictate that there be certain electronic controls. For inadvertent exposures, that's standard stuff. When you buy an insecticide or a household cleaner, there are standards about making that inaccessible to kids. Those could be applied. And with regard to potentially toxic ingredients, again, there are standards. You can set a maximum limit that your e-liquid or, more important, probably the emission from the device can't exceed a certain amount. And some you may be able to say you just can't have any of this stuff. It's got to be zero or non-detectable. But I want to emphasize the point that you can't set everything to zero, that the point here isn't for these products to be, as some have literally said, at the risk of breathing fresh air, if you could go find fresh air, but because there are standards for outdoor air which don't require that it be free of everything. Again, the point of these products is to be safer than cigarettes, not to be as fresh as mountain air. And flavorants, again, there are two aspects. I'm going to talk about them in a minute. But there's been both concern about their appeal to kids, but also concern that some of them may actually add to the toxicity of the produced vapor, and that's very important. And with regard to appeal to minors, the FDA has already banned sales to minors, and the UK actually has regulations that specify how you avoid marketing to kids, including things like how old the people in an ad have to not only be, but look. In other words, you can't go get a 30-year-old model who actually looks 12. If they look 12, that ad is forbidden. So I do want to talk about flavors because they've become a real lightning rod for regulation. San Francisco is on the verge of banning all flavors. We not only have states regulating, but we have municipalities regulating. CTP has not proposed that, but they've certainly signaled that they're concerned. And again, there are two concerns. One is as sources of toxic emissions, and we'll put that aside, and the other is for appeal. But in that regard, I want to talk a little bit about the importance of appeal in any regulatory scheme for e-cigarettes. Going backwards there. So here's a regulatory scheme. David Abrams and Ray Naura, who are here, had a big part in creating this. But the idea is on the x-axis is the harmfulness and toxicity of a product, and the y-axis is the appeal or its satisfaction. And cigarettes and cigarette smoking have a unique place in this scheme, which is they're highly toxic and hugely appealing, as they've shown over the years. Now, you could create a product which has way less harm and no appeal. And you would be very safe that no kids would ever use it, and it would be totally useless, because if it has no appeal and no one uses it, you haven't implemented harm reduction at that population level that FDA cares about. So what you really want is a product which is both less harmful and very appealing. Keep in mind that it has to compete with cigarettes in order to draw adult smokers away from cigarettes to e-cigarettes. And what this points to is that while we think of the regulatory scheme as simply restricting the activity of industry and, again, being prohibitive and restrictive, FDA actually has a mandate to promote the public health. And that means along with restrictions, certain things have to be promoted. So lower risk products should be appealing to smokers, and FDA should be doing whatever it takes to help smokers switch from smoking to lower risk products. Part of that is providing accurate appreciation of relative risks. At the moment, other government agencies, CDC in particular, are actually misleading the public about relative risks. And in the interests of public health, creating or making it possible to have innovation, whether it's in even lower risk or greater appeal to smokers, would again be in the interests of public health. So speculatively, why isn't FDA and CTP providing product standards instead of PMTA processes? Now, first of all, you should know that CTP, Center for Tobacco Products, is authorized to create product standards. In fact, they've suggested one for the level of NNN, which is a carcinogen in smokeless tobacco. Now, it happens to be a problematic standard, but the point is they have the authority to do this. But as has already been said, the statute sets up a specific pre-market tobacco application product, so I think that was sort of the natural course for them to go. But I want to suggest speculatively that there's another potential reason, which is that to create a product standard, you have to know a lot about the products and their hazards. And CTP may well feel that they don't know enough, and a PMTA process is a very expensive way to educate CTP. And finally, I want to make the point that PMTAs and product standards are not incompatible. You could have both. And that part of the PMTA process could be to say, if you meet these product standards, your PMTA is to show you meet those standards, and you're in. So this provides another regulatory framework that, as a non-lawyer, I think is compatible with what's in the statute. Thank you.
Thank you very much. I think the way we're going to do this, Sally, do you want to come sit here? I'll go stand there during the Q&A. I think that's... There we go. All right. First, I want to give the panelists the opportunity to respond to one another, viciously attack each other's arguments, and ask for clarification on points where needed. So, if any of you have questions for
What's my name?
each other, please do go ahead. No?
I'll just say that I think Saul's presentation was right on point. The idea that FDA could have taken a different approach, either through product standards or reducing the burden on companies to get through the PMTA process, that's the core basis of our lawsuit. Whether they had that authority legally to do that or not, and we argue that they did. And so we're waiting for the judge to issue a decision. But I think that's certainly something that we think FDA had the ability to do.
And I'll add, before we get to questions, 2 points. The first being on state taxation. We had brought up the Minnesota model of potentially being the worst in the country at 95% of wholesale. And this is actually a lesson in how the number on paper might not necessarily, comparing numbers, dealing with tax policy may not be the best way to analyze. I would actually say the worst in the country is Pennsylvania, because Minnesota's 95% tax only applies to nicotine-containing products. And if you are a Minnesota manufacturer, you are paying 95% only on your raw nicotine that you import into the state to manufacture. So if you're an out-of-state manufacturer of nicotine products, Minnesota's a disaster. If you're an in-state, it's actually an anti-competitive regulation that helps you. Pennsylvania, meanwhile, 40% of wholesale on everything, including $100, $200 devices. That has killed over 125 stores in the state. Thankfully, there is some progress being made towards reducing that tax to either 5 cents per milliliter or the West Virginia 7.5 cents per milliliter. And then one with regard to Dr. Schiffman, I'd highly encourage you to read the letter that Iowa Attorney General Tom Miller, along with Clyde Bates, David Abrams, Ray Naora, and others, sent to Scott Gottlieb, FDA Commissioner, 2 weeks ago. And it lays out a system similar to what Saul advocated for at the end. If you institute rigorous product standards, but you're stuck with a February 15, 2007 predicate date, well, you could send the signal, hey, if you are in compliance with these standards and you file your PMTA certifying to that, then you've done 90% of your work. If we could get something, assuming that we can't get the predicate date changed in Congress and we have to rely on Scott Gottlieb to delay the regulation, put out standards, put out better PMTA guidance, that is a actual reasonable path forward.
Before turning to the audience, I wanted to ask one question. I don't know if any of you have particularly strong views on this, but the opposition in Congress to the bills that exist, can you talk a little bit about the composition of the political opposition and motivations driving the...
Yeah, I think at some level it's a bit of a puzzle as to why a sensible evidence-based approach draws so much opposition from certain people. I think that there's probably a number of things going on. One is just either a confusion about the issue or a non-evidence-based approach to it of saying, well, an e-cigarette, sounds similar to a cigarette, and it, does deliver nicotine, so there is, some conceivable element of harm there. therefore, the best thing is to not have any of these products at all, and we should just try to sweep them all out of existence. And I mean, one New York City Council member, made a comment that e-cigarettes should be treated the same as cigarettes. If it walks like a cigarette and quacks like a cigarette, it's a cigarette. And you think, well, okay, but it doesn't kill like a cigarette. So that's maybe something that should be given some degree of significance. I mean, there are other objections which I guess are at least superficially appealing to rational concerns. The claim that e-cigarettes, conceivably could be a gateway to encourage smoking as opposed to a substitute that would reduce smoking. And I think as Sally and the others have addressed, the evidence just really, contradicts, those theories as does, I think, common sense. But you do hear at least some arguments that try to wrap themselves up into rational sounding concerns, but which don't really grapple with the actual evidence.
Right. Now, Alan, you don't even have to speculate. That was revealed in a letter to Scott Gottlieb about a month ago by, I think it was 7 or 11 Democratic senators who protested the 3-month extension that was given from August 2018 to November. And they basically, it was a litany of misunderstanding about, again, the flavors, the gateway, the normalization, all the things that now, 5 years later, 5 years of data collection have shown is just not the case. So it's almost a willful, ignorance of or resistance to facts.
I guess I would add I agree with all of that. I would add a couple of elements. There's an important historical cloud that hangs over this, which is that in the 70s, tobacco companies claimed that light cigarettes were better for you. The government actually agreed and reinforced that without really looking very closely at the data, and it turned out that was misleading. And so I think for a lot of people in the tobacco control movement, that looms as an experience you don't want to repeat. And so there's huge suspicion that all the evidence for safety is really a big conspiracy. Secondly, the focus on potential risks to kids has a huge emotional appeal. I mean, we all want to protect our kids, everybody else's kids, and so that tends to outweigh rational thinking about balancing risks and benefits. And finally, there's with regard to nicotine, there's a lot of misconceptions. Surveys show that most Americans think that nicotine is responsible for most of the harm due to smoking, which is not the case. Worse, they show that most physicians believe nicotine is the culprit for smoking-related harm. So the idea that e-cigarettes still deliver nicotine makes people really doubt that there's any change. And finally, we have a moralistic attitude about addiction per se that I think is an impediment. And in a sense, in the case of smoking, the addiction doesn't cause people to hold up 7-Elevens or steal from their grandmother's purse. It actually does worse. It kills people. And so in a sense, what we've got to grapple with is that if someone's already addicted as a result of smoking, we'd rather have them, even if they continue the addiction, not be killed by it. But that requires kind of thinking about how repugnant is addiction versus exposing addicts to real danger. And I think we're grappling with that with opiate issues as well.
And I will quickly add 2 points. First, I was at the New York City Council hearing where one of the testifiers used if it looks like a duck and quacks like a duck and walks like a duck, and I heard the best response to that ever, which was, well, sometimes it's a goose. And second, undeniably, the largest opposition to these products have come from the most liberal Democrats in the House and the Senate. One of our goals for 2017, 2018, especially going into the October appropriations bill, is to bring more Democrats around on this issue, and more importantly, for the Democrats that have already come around, we need them to go to their leadership in the House and Senate and actually communicate, look, not only do we support changing this date and fixing this regulation, but we think that the Democratic Party as a whole should stop making this an issue. It is certainly not winning them any votes, and it is actively turning people against the party and shutting down businesses, killing small businesses, et cetera. So that's part of our path forward is bringing more people on board and getting them to express that view to important people.
Thank you very much. With that, I think we're ready to open it up to the floor. We're going to start here up front. Please wait for the mic and then briefly introduce yourself. No extensive tirades, ideally, and please end with a question mark.
Thanks so much. Jeff Weiss from Enjoy. This is for Saul. Saul, I thought that was a great presentation on product standards, and from our point of view, that is the most sensible and productive path forward. In your view, are there any out there that currently exist, whether it's the AFNOR standards in France, the British standard, the BSI standard, that you see as a helpful and productive starting point for the formulation of standards?
Well, I've looked at those standards, but probably not deeply enough to endorse any one of them, nor am I a technical expert on any of the technical issues they deal with. But I do take hope from them in that they illustrate that standards can be promulgated. And they're also a good example of something that is very common in the product standards world, which is sometimes regulators initiate the standard, but it's often the case that industry groups and voluntary associations create standards which the regulators then accept and perhaps modify, and I think we're seeing examples of all of those.
Let's go right here, second row.
John Soliday, economist. To get a perspective on this, how much does the average cigarette decrease longevity, and how much does the average e-cigarette decrease the longevity of the user? For extra credit, what does a drink cost you? Thank you.
Actually, I need to punt to you on that about the longevity. I mean, obviously, Saul?
Well, I don't think one can denominate it on a per cigarette basis, for one thing, because it's not.
We certainly don't know about e-cigarettes.
Let me frame it a different way. Someone who smokes and doesn't stop has a 50% chance of dying due to smoking-related disease. How many years of life they lose does depend somewhat on how much they've smoked. The best estimates, and they are just that, is again a 95% reduction. Now, cigarette smoking has residual effects that continue to increase your risk after you've stopped. So it's very hard to answer that question. But again, the point is, if you could switch to an e-cigarette and do so early, the benefits are quite large.
And there was a researcher that actually looked at the data on Swedish snus, which is the reason why in Sweden they have the lowest rate of smoking, the lowest rate of tobacco-related disease and death. And that researcher kind of compared the days lost of life from a lifetime smoker versus the days lost of life from a lifetime snus user. It's been a while since I've read that, but I feel like Carl Phillips concluded it was something like 7 years off the life of a smoker versus 30 days off the life of a snus user. So big differences.
Let's go right behind you. Yeah.
Thank you. I'm Larry Flick. I represent the American E-Liquid Manufacturing Standards Association, AMSA. So Jeff, with regard to standards, AMSA has the only independently verified standards in the world, and is its former chairman is now the ANSI TAG chair and developing international standards through that process. And for Saul, all of the issues that your excellent presentation pointed out with regard to what regulation and standards-based regulation needs to address, I think are covered under H.R. 2194, Congressman Hunter's bill. But the most important thing about the Hunter bill, which I think is something that should be discussed, is that, with regard to the question about why the Democrats have opposed this or what the opposition has been, for the last 6 or 7 years, we've lost the political narrative debate. The tobacco control groups have done a good job at conflating an industry that was organically built by people who quit smoking into big tobaccos trying to do this all over again and addict another generation of children to nicotine. I don't know anybody that's quit smoking from vaping that thinks that they are using a tobacco product. And I think if we are going to change this narrative, we have to start with the premise that vaping products are not tobacco. They are nicotine products. They're relatively benign nicotine products. But every time CTP and FDA calls them a tobacco product, there is a public stigma that continues to grow and hurts the education effort to truly make the public aware of the benefits to public health from vaping products. So the Hunter bill takes e-vapor products, I think we all ought to stop calling them e-cigarettes as well, takes e-vapor products out of the tobacco product category, puts it into a category as a nicotine tobacco harm reduction alternative. And if we're going to win this debate, that's where we need to start, because people think they're tobacco products and conflate them with cigarettes and big tobacco. So your thoughts on... And Alan, you indicated that the Tobacco Control Act really was the problem. I mean, e-cigarettes, or I shouldn't say e-cigarettes, e-vapor products don't fit in there. There needs to be the flexibility of a new legislative statutory framework that works for CTP.
Yeah, I think these are very good points. I mean, as I mentioned, one of the Hunter bill's attractions is that it does enact a completely separate regime for vapor products for regulatory purposes and does not put them under the tobacco product category. Yeah, I do support, of course, all the efforts to try to get the FDA to adopt a more sensible approach, to try to change these things to litigation. Obviously, if those succeed, that's good. But, I do think no matter what happens on that it's always going to be a mismatch between the way the statute works and the goals that one is trying to achieve. I mean, yeah, the February 15, 2007 predicate date, it really was designed, I think, to put the cigarette industry into stasis and say, we're really just not going to allow any new products to be introduced beyond the ones that already exist. Well, that's a reasonable objective, I think, for cigarettes. They've been around a long time, and a lot of products have been developed, and there's really only so many ways to kill people that you need to have on the market. So, I think that's maybe okay that you aren't bringing out new products, but it obviously doesn't remotely fit with the for e-cigarettes that didn't exist in 2007, and the whole premise of the pre-market review application process of having to show how this, is going to, how each specific product is going to make a contribution to public health. Again, it doesn't make sense to try to insist on that standard for e-cigarettes, a standard that really can't be met and doesn't really, make sense. So yeah, to my mind, you really do just want to change the whole statutory framework if you can. If you can't, then of course these other approaches, are good. But
I would just add to that real quick. What we saw happen when FDA initially tried to regulate cigarettes as drugs is very similar. It sort of mirrors what's happening today. They attempted to capture tobacco as drugs. They failed. And then the law was changed to create a new category of product to give FDA that authority. We're in a very similar situation now. I think ultimately the best and most sensible way to regulate these products is to give FDA authority, but separate authority that doesn't pigeonhole them as drugs or tobacco products. We also see a lot of loopholes and gaps that can arise when you do try to force these products into one of the existing categories. We're seeing a lot of tobacco-free nicotine products. What happens then? How is FDA going to regulate nicotine that is not derived from tobacco? Components and parts, that don't contain anything made or derived from tobacco. Should those be considered tobacco products. So creating a new category of vapor products or e-cigarettes or whatever you want to call them that gives FDA ability to capture the universe of products and regulate them in a sensible way that doesn't presume them to be harmful, I think is ultimately the way that this will be solved.
I would just like to add a caution that dividing the world into tobacco and not tobacco is going to get us just into a different dilemma because, for example, Greg mentioned snus, which is a product originally developed and popular in Sweden, which is smokeless tobacco that's prepared in such a way that it has very low levels of tobacco-specific nitrosamines, which are kind of the major bad actor in smokeless tobacco. And those products are also hugely safer than cigarettes. There's actually been an application by a Swedish company to be allowed to make health claims. That was turned back. But the point is, the distinction is not whether you're tobacco or not, but whether you're safer or not. And there's similarly been an application from Philip Morris for a product that is tobacco but doesn't burn tobacco. So if we keep our eye on the prize, which is protecting the public health, that is the important concept, not whether you come from a particular plant or not.
Let's go over here.
Hi, I'm Ray Nyora, citizen of the United States, resident of Montgomery County, Maryland, and also adjunct professor of public health at Johns Hopkins. Getting back to influencing the FDA, what I've heard on many occasions from people who will go unnamed is that everything they're doing is a result of a statutory requirement. So anytime people try to push back, they say, what we're doing and exactly what we're doing is the statutory requirement. And equally emphatically, these unnamed people also say that they will deal with products on a case-by-case basis, which you've addressed. So aside from litigation or changing legislation, what are the options open to people to actually effect change at the FDA? Because I actually disagree with those two positions, as I know you all do.
Well,
Go
ahead.
The efforts that have been made in the past couple weeks, reaching out to Scott Gottlieb, there's been an outreach campaign going on that has sent thousands of consumer letters to Secretary of Health and Human Services Tom Price, who was smart enough in 2009 to vote against the Tobacco Control Act, despite, I'm sure, fervent lobbying to support it. In terms of changing the attitudes at CTP, I do not know, because I don't know where they derive their applicants from, but it's certainly nowhere that has any experience. There's no one there that has any experience in the tobacco industry. Probably no one there has ever smoked. So it is certainly a tough lab to penetrate, it seems. But at the top, more people in public health, more experts coming out and saying that this system needs reform and that there's ways that FDA staff can change things. That's what we need in my mind.
Don't you think that in some way they've had tacit cover from the CDC, which is so, demonized might be a strong word, but certainly not granted these products their credit for the benefit that they afford. Has anyone heard anything about an incoming CDC person and whether they might be kind of more enlightened on this issue?
I have not heard, but the bad news that I've noticed over 7 years is that NIH, National Cancer Institute, CDC, they all have an abstinence-only mindset. There is not much room for disagreement. And even worse, if you are a scientist looking for funding, whether it's from CTP or from the NCI, if you are seeking to explore benefits, if you are seeking to perhaps compare accurately cigarettes to alternative products, you seemingly stand less of a chance of getting a large grant than if you are a San Francisco professor that's known for any negative, he'll take it.
sorry to dominate this part, but even though you mentioned the opioids, I mean, that is just talk about an elephant, in the room. When it comes to that issue, folks are bending over backwards, and rightly so, to pursue harm reduction efforts. And the very same people often who are so resistant to vaping. I mean, the contradiction and frankly, public health hypocrisy is just striking. I mean, we can talk. You could write a thesis, I suppose, about the moral intuitions and the politics underlying that. But when you confront folks with this, or have we confronted folks with this? I don't know. What do they say? Because it's such a striking contrast.
Well, on that note, another one of my hopes is you have groups like the Drug Policy Alliance. The founder of the Drug Policy Alliance, which has a lot of resources courtesy of George Soros and other donors, Ethan Nadelman, he spoke at the Global Forum on Nicotine 2 weeks ago in Poland, and he talked about how the anti-drug movement needs to be a part of the new nicotine movement, and the new nicotine movement needs to be a part of the anti-drug movement. So I am hopeful, I've used that word many times today, very hopeful that we may start to see these groups that have much better ends with Democratic legislators, much better ends with certain segments of the public health community that study harm reduction, that we may see a change in dialogue on this issue. And on the note of heroin, very quickly, and then I'll shut up finally. There was a group that actually went to West Virginia, and they had a meeting with a lot of health departments from West Virginia about tobacco harm reduction. And the message that they seemed to come away from many of the departments was, look, that sounds nice and all, and we know smoking kills, but we're dealing with the opioid crisis, and so tobacco is second, third, fourth priority. So that's even getting in the way in many areas that have very, very high smoking rates of getting people on board because they're already so focused on opioids.
Just to quickly go back to Ray's question, I just wanted to note that when FDA initially announced the 3-month delay in the compliance deadlines, the reasoning was to give the new leadership time to consider the rule and its impact. And so presumably that presents an opening for folks to reach out and try to influence that change, along with letter campaigns. There was recently a citizen petition that was filed. I think Enjoy was the primary author, and a bunch of trade associations arguing that the PMTA deadline should be further extended to give more time to companies to comply. So,
good. Let's do one last question all the way in the corner over there. Sorry, please wait for Mike.
This question may be best for Greg, since you're the head of the association. What are the numbers currently for the number of businesses that you expect to be adversely impacted, perhaps put out of business due to the regulations?
There are probably 10,000 vape shops or tobacco retailers that have a heavy specialty in vapor, probably another 1,500 wholesalers, manufacturers, et cetera. Then you have the bottling companies and the people doing the testing. So we ballpark it at least 75, 100,000 jobs. Heard estimates higher, heard estimates a little lower, but undoubtedly there is a lot of people that are going to be impacted if this goes down.
Some of that, of course, would be made up for by new jobs in the tobacco industry.
Yes, and hey,
in healthcare,
FDA is constantly hiring people to enforce the deeming regs. So
and read the applications.
Can be narc for a living.
Exactly. All right. Well, thank you very much. I think with that we will conclude today's event. Thanks to the panelists for coming, and thank you all for coming.
Thank you all.